This is a production of Cornell University.
All right, here we go. As I have been introduced, I am a wage hour investigator and have been for almost 25 years now. This presentation, I will start now, is going to cover the legal obligations of agricultural employers resulting or relating to the H-2A program and relates to the H-2A regulations, which became effective on March 15th, 2010. Additionally, there are 3 other laws that Wage and Hour administers which relate to agricultural employment, and those are the Fair Labor Standards Act, the Migrant and Seasonal Agricultural Worker Protection Act, and Field Sanitation Standards. I won't be covering them, but just know that they exist and, you know, they could potentially affect. Okay, so when there is a shortage of U.S. workers to perform manual farm work, the H-2A program allows foreign agricultural workers to enter the country on a temporary basis under appropriate conditions. Basically, H-2A is a non-technical term based upon the temporary worker section of the Immigration and Nationality Act, which is section 101, A15, H-2A. The H-2A provisions of the INA are administered by the Employment and Training Administration and the Wage and Hour Division of the U.S. Department of Labor. ETA is responsible for the application and certification process, and Wage and Hour is responsible for the enforcement of the contractual obligations which apply to the employment of H-2A workers and workers who are engaged in corresponding employment. As it says, ETA is responsible for issuing or denying labor certifications. So included within that jurisdiction for ETA are determinations related to such issues as the availability of U.S. workers, positive recruitment, the existence of a strike or lockout, the methodology for establishing.
And I was like, I swear.
Okay.
Okay, Belinda, keep going. We'll turn the sound off on somebody.
Okay, the adverse effect wage rate, which is abbreviated AWR for us, AEWR, the offer of employment to U.S. workers for up to 50% of the contract period, and similar matters. The AWR, that adverse effect wage rate, is the rate determined by the administrator of ETA that must be offered and paid at a minimum to every H-2A worker and every domestic worker for a particular occupation in an area of intended employment in which an employer seeks to employ H-2A workers. Okay. Wage and hour responsibilities. WHD enforces the contractual obligations related to wages, transportation, meals, and housing. So, as I said, we're responsible for all of the contractual obligations for H-2A workers and workers in corresponding employment. Corresponding employment applies to the employment of workers who are not H-2A workers by an employer who has an approved H-2A application in any work included in the job order or in any agricultural work performed by H-2A workers. That sounded confusing to me when I read it. So basically it's any worker who is eligible to work in the United States, who does any occupation listed in the job order, or who is working alongside an H-2A worker, maybe not in an occupation listed on the job order, but doing the same work at that time, they would be required to pay that adverse effect wage rate to any corresponding U.S. worker. Okay. Oh, and to qualify as corresponding employment, the work must be performed during the validity period of the job order. And just a note on that as well, if, for example, your job order starts on April 1st, but your H-2A workers are not in the country until May 1st, the adverse effect wage rate for corresponding U.S. workers is going to go into effect on April 1st, even if the H-2A workers are not in the country yet. Just keep that in mind. All right. Wage and Hour is authorized to conduct inspections and in appropriate circumstances to pose penalties, collect back wages, seek injunctive relief, recommend recommend revocation of existing labor certification, and debar from future program participation. Wage and hour also enforces the record requirements of the regulation. Okay, so for the next slide, I'll just read this off. Agricultural employers who anticipate a shortage of U.S. workers may file an application with ETA. The application must include a job order which explains the working conditions, pay, and benefits. And then for information related to ETA's responsibility, there's the link there. This presentation focuses primarily on wage and hours responsibilities and related employer obligations. Okay, so definition of agriculture. Section 3F of the Fair Labor Standards Act gives the definition. Also, section 3121G of the Internal Revenue Code. It also includes the pressing of apples for cider on a farm and logging employment. So work performed within the scope of either the Internal Revenue Code or the FLSA definition of agriculture, which includes farming in all its branches, the raising of livestock, bees, fur-bearing animals, poultry, forestry, or lumbering operations. Logging employment has been included in the definition of agriculture for H-2A as of January 17th, 2009. Excuse me. Logging employment is defined as operations associated with felling and moving trees and logs from the stump to the point of delivery, such as, but not limited to, marking danger trees and logs to be cut to length, felling, limbing, bucking, debarking, chipping, yarding, loading, unloading, storing, and transporting machines, equipment, and personnel to and from and between logging sites. So that's just kind of telling you what we consider agriculture. Now we go to types of employers. There are 3 of these. The fixed site employer is going to be a person who owns or operates a farm, ranch, processing establishment, cannery, gin, packing shed, or other similar fixed site location where agricultural activities are performed, and who recruits, solicits, hires, employs, houses, or transports any workers subject to the H-2A regulation. An agricultural association is any nonprofit or cooperative association of farmers, growers, or ranchers incorporated or qualified under applicable state law that recruits, solicits, hires, employs, furnishes, houses, or transports any worker. An agricultural association may act as the agent of an employer or as the sole or joint employer of any worker subject to the H-2A regulations. And the H-2A labor contractor is an employer, that is not a fixed site employer, agricultural association, or an employee of a fixed site employer or agricultural association, and who recruits, solicits, hires, employs, furnishes, houses, or transports any worker subject to the H-2A regulations. Okay. Then we have types of workers. There's H-2A and then the non-H-2A workers and corresponding employment. The corresponding employment applies to the employment of workers who are not H-2A workers by an employer who has an approved H-2A application and any work included in the job order or any work performed by H-2A workers. The work must be performed during the validity period of the job order. I basically went over that before. Just keep in mind that as soon as the job order comes into effect, that adverse effect wage rate is applicable. And that's about all I would have to say about that. Corresponding employment, corresponding workers may also be protected by the Migrant and Seasonal Worker Protection Act. So workers in corresponding employment may be subject to that, but H-2A workers are not migrant and seasonal workers by definition. So they are not subject to the Migrant and Seasonal Worker Protection Act. Okay, employer obligations. So this is what is required. First, the job offer must contain the employer obligations. A copy of the job offer must be given to each H-2A worker no later than the time of visa application, and to each corresponding worker no later than the first day of employment. And you can see there what the obligations are: disclosure of wage requirements, the 3/4 guarantee, housing requirements, meals, transportation, preferential treatment, assurances and obligations, and record keeping. Now we'll talk about disclosure. Each worker, must receive a copy of the work contract or a copy of the job order if no separate contract exists. The work contract must include beginning and ending dates, conditions of employment, hours of work, rates of pay, and crops. We have always suggested that it's easiest to just give a copy of the job order, because everything in the job order must also be included in the work agreement in order to satisfy the requirement. So a written work contract which specifies the terms and conditions of the employment agreement between the H-2A employer and a worker may exist. If the written work contract exists and it provides the same or greater and/or additional labor standards as those in the job order, the work contract will be enforced by wage and hour. It would apply to both H-2A and corresponding workers. If no written work contract exists, the job order and certified application become the contract which is enforced. And just to recap, that disclosure must be in a language the worker understands, is necessary or reasonable. If they speak Spanish, it should be in Spanish. A copy of the work contract must be provided to H-2A workers no later than the time of visa application. A copy of the work contract must be provided to corresponding workers no later than the date work begins. Wage requirements. The employer must pay the higher of the applicable, which would be either the adverse effect wage rate, the prevailing piece rate or hourly wage, federal or state minimum wage, and the agreed upon collective bargaining rate. The employer must pay no less often than semi-monthly, and in New York State, it is actually weekly. You have no other option. It must be weekly because of New York State law. Only deductions required by law or disclosed in the contract are permitted. So the prevailing hourly wage rate is determined as a result of a state agency prevailing rate survey. The AWR is the rate determined by the administrator of ETA, Office of Foreign Labor Certification, that must be offered and paid at a minimum to every H-2A and corresponding worker. Pay day must be stated in the job order, and as I said, in New York State, it must be weekly. The employer must make deductions required by law. Any other deductions must be disclosed in the job order and must be reasonable. And basically, reasonable turns out to be voluntary and cannot include any profit to the employer. So that is that. When the worker is paid by a method other than an hourly rate, the worker must receive an average hourly rate that equals or exceeds the amount stated in the work contract. If not, the employer must supplement the earnings so that the worker averages the stated hourly rate. And just as an example, I can provide to you, if the adverse effect wage rate is $9 an hour, this is an old example, and piece rate is 75 cents a basket, you have 40 hours worked in the week, total baskets of 500. If you multiply 500 by 75 cents, that equals $375. If you divide 375 by 40, you get $938. You're in compliance because you are above that $9 rate. Okay. The 3/4 guarantee. Employers must guarantee to offer employment for at least 3/4 of the total hours promised in the work contract. Guarantee period begins on the first workday after the worker arrives at the place of employment, so after the beginning date of the contract, and ends on the date the contract expires, including any extensions. Failure to meet this provision would require the employer to supplement workers' pay to meet the 3/4 guarantee. So an employer must guarantee each worker payment for a total guaranteed number of hours equal to at least 3/4 of the workdays during the contract period. An employee is not required to work more than the specified daily number of hours or on federal holidays or the employee's Sabbath. The employer may count all hours actually worked by the employee. And just as an example, if your contract is 4 weeks, there's 5 days a week that you're offering in the contract, 8 hours a day. That's 160 hours, multiply it by 3/4. Your guarantee to the worker is that they will be paid for 120 hours. Okay. Housing. Housing must be provided at no charge to the employee, inspected before occupancy, and maintained during occupancy to meet the appropriate OSHA or ETA standards. So the housing must be provided without charge to H-2A and corresponding workers who are not reasonably able to return to their residence daily. If rental or public housing is provided, charges must be paid directly to the housing management. The SWA, the State Workforce Agency, is responsible for assuring that housing is inspected prior to occupancy. Housing standards are found at 29 CFR 1910.142 for OSHA. And if the housing was constructed before April 3rd of 1980, you can use the ETA standards, which are at 20 CFR 654. So I'm just going to go through the housing safety and health requirements. Shelter must have protection from the elements, 50 square feet per occupant, beds and storage for each occupant. Floors must be smooth and tight. There must be proper ventilation, windows that open, all openings are screened, cooking facilities, and compliance with all state and local codes. Here locally, that's going to mean that you're going to have fire or smoke detectors. That's one of the things that we would be looking for. One of the biggest violations we usually find are that these screened openings have holes in them. Moving on. The site itself must be clear of debris and uncontrolled weeds on the grounds. There must be adequate drainage and adequate size to prevent overcrowding. The water supply, you have to have safe drinking water, 35 gallons per person each day. Toilet facilities, they have to be adequate for the capacity of the camp. Access without passing through sleeping rooms, provided for each sex if appropriate, well ventilated, lighted day and night, and that's if they're separate from the housing, if they're in a separate building. Adequate supply of toilet paper and maintained in a sanitary condition. Laundry, hand washing, and bathing. You must have 1 hand washing basin to 6 occupants, 1 shower head to 10, 1 laundry tub for 30, 1 slop sink. Flowers must be non-slip with proper drainage, must have hot and cold water, and it must be maintained in sanitary condition. Lighting, at least 1 ceiling light type light per room and 1 electrical outlet per room in accordance with state and local codes. Refuse disposal, fly tight trash container. That's another area where we see issues because lids tend to get lost. The garbage container must be kept clean and emptied at least twice a week. The kitchen and dining hall, maintained according to state and local codes, adequate to the size of the camp, separate from the sleeping quarters, has proper refrigeration of food, and then insect and rodent control, prevent infestation by and harborage of animals or insects, vermin, or pests. And then first aid, you must have adequate first aid facilities readily accessible at all times. That's another area where we see, you might have a full stock first aid kit at the beginning of the contract. And when we come in to conduct a housing inspection, they've been emptied. So keep an eye on those. And then sewage disposal facilities connect to public sewers when available. Reporting disease to appropriate local health authorities. You must report any individual with communicable disease and report any camp outbreak of illness. Meals, the employer must either provide meals or provide cooking facilities. If meals are provided to H-2A workers, they must also be provided to corresponding workers on the same basis. Just will note that one of the things we have noticed lately is that the transportation for workers to go to the store to pick up groceries and such, if there is an actual employee who's driving those workers to the store as opposed to you, the employer, that employee is due the adverse effect wage rate for those hours of driving, not the time at the store, but the driving. And then they must also have that disclosed in the job order that there will be driving, just so you're aware. Inbound transportation. The employer must provide or pay for transportation from the place of recruitment to the work site. The employer may provide an advance for the most economical means, and this can be recovered from workers' wages if this has been disclosed. At the conclusion of 50% of the contract period, the cost of inbound transportation and subsistence must be reimbursed to the worker. FLSA obligations apply independently of the H-2A requirements. So first off, the amount for transportation must be no less than the most economical and reasonable common carrier transportation charges for the distance. And it must be from the place of recruitment. If you have workers that have been coming back to you for multiple years, the place of recruitment is their home. So you would pay from home to consulate, consulate to place of employment, and on the reverse, the same back to their home. If the employer has not advanced or provided transportation and subsistence costs to the workers, and the worker has completed 50% of the work contract, the employer must pay the worker for transportation and daily subsistence from place of recruitment to place of employment at that time. The daily subsistence changes yearly. You need to check the Federal Register for that. And then the part about the FLSA applying independently would be, as an example, if a worker only works one day in the week and say their pay ended up being less than, if you add in the transportation costs, if the total amount of pay divided by the total number of hours they worked ended up less than the federal minimum wage of $7.25, then you would have to bring them up to $7.25 in order to be paying them in compliance with the Fair Labor Standards Act. So just in case that ever comes up. All right, outbound transportation. If the worker completes the contract period, the employer must either provide or pay for transportation and subsistence from the living quarters to the place of recruitment by most economical means, or from current employer to subsequent employer, absent agreement from new employer to pay. So, excuse me, you're not obligated to pay the outbound if the H-2A employee is sent on to another employer who has agreed to pay the return transportation. And you are not obligated to pay the outbound transportation if the worker quits or is terminated for cause and the employer notifies ETA. Both US workers and H-2A workers, they have to notify ETA. And DHS, Department of Homeland Security, that only has to be the H-2A workers, and that has to be done within 2 working days. Daily transportation. The employer must provide transportation between the workers' living quarters and the work site at no cost to the workers. Transportation safety. All employer-provided transportation must comply with all applicable federal, state, or local laws and regulations. At a minimum, this transportation must provide the same vehicle safety standards, driver licensure, and vehicle insurance required under 29 CFR 500.105 and 29 CFR 500.120 through .128. Okay. Some of the other state laws in New York State that would be applicable would be a seat belt for every passenger, a commercial driver's license if applicable, and speed limits. Those are some of the things that they'd have to obey. Preferential treatment. The employer's job offer to corresponding workers must include at least the same benefits, wages, and working conditions provided to H-2A workers. The employer may not impose restrictions or obligations on workers in corresponding employment that are not imposed on the employer's H-2A workers. The employer must provide employment to any qualified eligible U.S. worker who applies until 50% of the work contract period has elapsed. And just a note on the restrictions, a lot of times we'll see that drug testing is something that is required in the job order. If you're only drug testing US workers and not H-2A workers, wage and hour would consider that preferential treatment. Okay. Assurances and obligations. The employer must assure that there have been no layoffs of similarly employed US workers within 60 days of the date of need, except for lawful job-related reasons. And if such a layoff has occurred, the employer must first offer the job opportunity to those laid off US workers before hiring any H-2A workers. A layoff is only permissible if all H-2A workers are laid off before corresponding workers. And if the worker is not able, willing, or qualified for the job opportunity, the employer may refuse to hire the worker, but must document that in the recruitment report. Tools, equipments, and supplies required to perform the assigned duties must be provided at no charge. State workers' compensation insurance or its equivalent must be provided at no cost. If completion of the contract is impossible due to an act of God, the employer may request that ETA approve cancellation of the job order. A determination is made by the ETA certifying officer. The employer must try to transfer the worker to comparable employment acceptable to the worker, consistent with the INA. And if a transfer is not possible, the employer must return the worker at no cost to the place from which the worker came. So if services are not required for reasons beyond the control of the employer due to fire, weather, or other act of God that makes fulfillment of the contract impossible, the employer may terminate the work contract, again, determined by the ETA certifying officer. You can't make the decision yourself. You have to go to ETA and get that determination. In the event of such a termination, the employer shall fulfill the 3/4 guarantee for the time that has elapsed from the start of the contract to the termination due to the act of God. And if their workers are not transferred, they must be returned to the place from which they came. And then finally, employers and their agents are prohibited from seeking or receiving payments from workers related to obtaining labor certification. So government mandated fees such as visa application, border crossing, and visa fees are integral to the employer's choice to use the H-2A program and are fees that must be borne by the employer. Recruitment of the foreign workers is an expense to be borne by the employer. Passport fee, like obtaining a passport, would be an expense that would be borne by the worker. And then employers must comply with all other applicable federal, state, and local laws and regulations, including the prohibition against holding workers' passports or other immigration documents. Employers must display a poster at the job site, which details the rights and protections for workers in a conspicuous location and in a language common to a significant portion of the workers. We have them available in both Spanish and English. You can order them over the internet, or you can call our office in Buffalo and we can get one for you or mail one out to you. And then the H-2A labor contractor has certain, another obligation added onto them, which would be a surety bond. Every application requires one, and the amount is dependent on the number of employees listed in the application. The bond must be written to cover liability incurred during the time of the job and must remain in force no less than 2 years from the expiration of the order. Again, that's only for the H-2A labor contractor. Record keeping, the following earnings information must be maintained: field tally records, number of hours offered and worked, the beginning and ending times of work each day, the rate of pay, earnings per pay period, home address, and deductions. Records must be maintained for 3 years, and deductions must be explained in writing. If the hours worked are less than offered, the records must show the reason. For example, you have 8 hours of work available on a Monday, and the worker says, I'm too sick to come. You document 8 hours offered, employee sick. The employer must provide each worker with a written earnings statement no later than each payday. The earnings statement must include all required payroll information. One of the things that we do notice missing on that pay stub is your federal employer identification number. That must be on the pay stub. And if you do pay by piece rate, you must include both hours worked and pieces earned. So compliance assistance materials would be the Immigration and Nationality Act, the regulations of 20 CFR Part 655 Subpart B, and 29 CFR Part 501, fact sheet number 26, Section H-2A of the Immigration and Nationality Act, workers' rights card, and the poster. And then information on the application process. Any office of the U.S. Department of Labor, Employment and Training Administration can assist interested parties in the H-2A application process. ETA will specify who may apply, where to apply, and how to apply. And then you can see the website there. Any office of the U.S. Department of Labor, Wage and Hour Division can provide compliance assistance with the H-2A worker protection requirements. And there is our website. You can also call our office. We are more than willing to provide compliance assistance. This will not trigger an investigation, I promise. We much prefer to provide the information ahead of time than have to come in on the back end. And then you can contact us at the Wage and Hour Division homepage, www.dol.gov/WHD. We have the toll-free information and helpline, which is 1-866-4-US-WAGE, or you can call or visit the nearest Wage and Hour Division office. Our office number is 716-842-3240. And that's our general disclaimer. Informational only, does not carry the force of legal opinion. And that is it.
Thank you, Belinda. I'll open this up for questions. You can either ask, since we have a small group, you could unmute and you could ask Belinda directly, or you could put something into the chat.
I have a question regarding, I guess it'd be receipts or reimbursement for things like inbound travel. Is
Okay.
there a set amount? How are we determining what that cost of transportation is from the employee's home to the embassy, and then cost of hotels and things like that? Do they need to provide receipts, things like that?
They don't the receipt is not required, but if they do provide a receipt, then obviously you would pay what they've incurred. If they don't provide a receipt, then what you can do is look at the most economical means of transportation to get from, say, their home to the consulate. Generally, that's going to be a bus. If they choose to take a flight instead of a bus, you're still only obligated to pay that bus fare. The hotel and subsistence in usually Monterey, most of the time I've seen that workers do tend to keep the receipts for those, maybe not for food, but for hotel for sure. And then for subsistence, you could just go with the daily rate that's in the Federal Register. Is that helpful?
It is, I mean, when I do the same thing when the employees return, is that I will look up, say, the cost of a bus to return them to their home, and then the cost of a plane. And even if the cost of a bus is cheaper, they prefer to go on the plane. So I just kind of allow the subsistence from the cost of the difference in the cost of the bus and the plane, and allow that for a subsistence. But I'm particularly talking about when they are going from their home, when they get called to come to the embassy, how to figure out what I should be paying them for that transportation. Now, you say going on, say, Greyhound and, a Greyhound site or something like that, and looking up the price that they would pay.
Yep, that's generally what I have done in the past when an employer hasn't done it, is I will just Google transportation from, say, Veracruz to Monterey, and look and see what the most economical price is. It might not be the best way to get there. It might take 2 days. It might be something they would never choose, but the regulation only requires that you pay the most economical way to get there. So if they're not providing you with a receipt saying, this is what the cost was that I incurred. And again, even if they do, say they decide to take a flight from Veracruz to Monterey, you are only required to pay that minimum, the most economical way of doing it. So you could still look it up and pay that rate, just as long as you document everything. That's all I would say, is if you go on Google and you find the bus cost, just print out that page. So if you have a wage and hour investigator come to see you, say, this is what I did, here's the information, and we'll look at it and say, yep, okay, great, thank you.
Okay. All right. Yeah, I mean, I was just worried about whether I have to take their word for it. I have also heard that there was an average amount that was being paid. So, all right, I just want to make sure I was on the right page.
Definitely not the average amount. It's going to change for every worker. It's going to change depending on where they're coming from. So definitely not an average amount. As far as, again, taking their word for it, if they say they, if they give you an amount and you think it's ridiculously overpriced, you can look up what the most economical method is and document it and provide that as the reimbursement.
Okay, thank you.
Yep.
Belinda, I had a message that came in the chat just to me, and they want to know if it's possible to go over the adverse effect wage rate again, please.
Okay. I'm not exactly sure where you want to go over it, if it's and how it's determined. I don't have anything to do with that, basically. It's determined based on surveys, and you would get notification through the Federal Register, again, what the adverse effect wage rate is. So if it's as far as enforcing it, I can tell you that the adverse effect wage rate would be in effect from the date the contract goes into effect until the date the contract is no longer in effect. And maybe the question might be with US workers who are doing that same work. And I kind of gave that example. If the contract goes into effect on April 1st, but your H-2A workers don't show up till May 1st, all your US workers who are doing work in that job order are required to be paid the adverse effect wage rate starting April 1st. As far as any other questions that might come up about it that we've seen, a lot of times a job order will only be for, say, working in the fields, cultivating, weeding, picking, that kind of thing. But there is a time towards the end of the season where the employer is short of workers in the packing house and decides to bring workers in from the field, H-2A workers, and from the field. That's not in the job order. But once an H-2A worker comes in and starts doing that work, everyone who's doing that work is subject to the adverse effect wage rate. So everyone working with that H-2A worker would be paid the adverse effect wage rate while they're working with an H-2A worker. And there might be times where something isn't listed in the job order, but it is a regular duty. And I mentioned driving as being one of them. If it's something that the H-2A worker is doing, they're required to get the adverse effect wage rate for anything that they do. I don't know if that answers the question, but if they have something more specific, I would be more than happy to try and go there.
Dave, do you want to unmute and ask your question? He did write back saying specifically paying for H-2A drivers, the AEWR versus hourly rate.
Yeah, that would definitely be something that we've seen lately. Any time that an H-2A worker is going to be driving other employees, H-2A workers, either one, corresponding US workers, H-2A workers, whatever, if they're driving them as a condition of their employment, that, you know, it's required by the employer that they do this. And that includes going to the store, because the employer must provide means for them to get to the market to purchase food. That employee is required to be paid the adverse effect wage rate for that time. Now, if it's not in the job order, and you have a regular US employee who is driving your H-2A workers to the store, they can get their hourly rate.
I have another question related to the minimum wage or the hourly wage relating to piecework. When you gave the example before, if a worker was doing piecework, that obviously they have to make at least the minimum wage on the job order. Does that apply to each individual crop? And I'll try to explain what I'm talking about. We have several crops where we have piece rates listed in our job order that are different because either the box sizes are different or the type of crop it is. At the end of the week, when you are determining whether or not for a particular crop they have met the minimum needed, meaning the minimum wage for the contract, is that determined per crop or is it determined overall? I don't know if that's you.
Yep, I understand it. Yep. If it is, or at the end of the week, it is actually based on the total amount paid overall. It's not per crop. So you would determine how much the worker earned, divide it by the total hours. And as long as the total per hour is above the adverse effect wage rate or the piece rate if it's higher,
Good to go.
then you're in compliance.
Okay. Thank you.
Yep.
Okay, one more question related to the piecework.
Okay.
On our earnings statement or their pay statement, we have several crops that are listed at the same piece rate. For instance, radishes, cilantro, and dill, they are all listed as, or they all receive the same, all have the same piecework rate. Can they be combined, or do they have to be listed separately, that they picked this many cilantro, this many radishes, this much dill? Do each of those items need to be listed separate, or can they be grouped together as, let's just say, the piece rate is $1.50. They picked so many boxes at $1.50.
You can do it as one group of, if it was 50, 50, and 50, they picked 150 at $1.50. You can combine that as 150 pieces at $1.50. Yes.
Okay.
Other questions? Take advantage of Belinda while we have her here. Okay, seeing as there aren't any more questions, nothing's coming over chat, I suppose we can log out. Belinda, I do want to thank you for a wonderful presentation. I don't understand so much of this, being a production person, but thank you so much for joining us today.
You're welcome. I was happy to do so.
Okay.
This has been a production of Cornell University, on the web at cornell.edu.